just to start off, can you give us a little bit about your story and your background? Like, how did you get involved in TCPA litigation and like in TCPA law?
Yeah, sure. So before I answer, and I will, I just want for those folks that are familiar with all the content we put out on TCPAworld.com, you're probably looking at me thinking, who is this guy wearing a collared shirt? And what's this background? Like, what the heck's going on? So Troutman Amin, LLP, which is my law firm, we just moved in. We're in the post-COVID era. We've left our home offices where I had that beautiful backdrop with the big czar sign. And now we're in an office here in, I know some of you are in Southern California, we're in Irvine. You can see the spectrum right back here behind me. Very nice little office space. And so we've decided as a firm that we're going to wear collared shirts and look like actual lawyers and not wear ball caps all day. Although I really appreciate you, of course, having the cap backwards, making me hunger for the casual attire that I've been wearing for the last 3 years. So I started off as a trial lawyer. That's why I went to law school. My whole youth, from the time I was about 8 years old, tells you what kind of a weird, there you go, Diego, what kind of a weird person I am. Ever since I was 8 years old, I wanted to be the world's greatest trial lawyer. That's all I wanted in life. 8, 9, 10, 11, 12 years old. That's all I wanted. I went to Berkeley undergrad, focused on pre-law and trials in particular, went to law school, did trial advocacy. I was UCLA Law's premier trial advocate as a law student. I went right after law school to go try cases at a insurance defense firm where they, very few firms will let you try cases as a first year to a jury. This firm did, and so I went to that firm. And then I went to a different firm that had about 160 lawyers, and I was essentially the only trial lawyer. Me and one other lawyer did all the trials for the entire firm. And I really thought that was going to be my entire career. I was just going to be a trial lawyer. That was it. That's all I wanted to do. And then I tried a series of cases against the Armenian mafia for Wells Fargo. Really interesting. And we won the cases, and we got to be pretty close with some in-house lawyers over there at Wells. And about 4 months later, they call me up and they're like, "Hey, Eric, we've got a TCPA class action. It's with some big firm that we work with in LA, but opposing counsel won't call us back. Can you call the guy and get an extension for us?" And I was like, "Yeah, sure, no problem." So I call the guy, and 20 minutes later, I've got the extension. And 4 hours later, Wells calls me and they're like, "Hey, we're just going to give you the case." And at that time, again, I'm just a trial lawyer, right? I've never handled a complex litigation matter. I've never handled a class action. I'm rarely in federal court, and I'd never heard of the TCPA. This was back in 2008. And essentially from that day on, I fell in love with the statute. I fell in love with the complexity of the litigation, the incredible high stakes, right? When you're representing Wells Fargo in federal court in a case that's worth 40 or $50 billion, that's exactly the sort of thing that's attractive to me. And very quickly, I became known as the czar, which we'll talk about here in a second. But I handled approximately 300 cases for Wells Fargo. Then I became national counsel for Ally Financial, national counsel for US Bank. And once you're handling huge portfolios of cases for major banks, it becomes very easy to pick up other clients. And before I knew it, I was the single most experienced TCPA defense lawyer on the planet, and that's been my career ever since.
So really, you kind of go back to that moment where you with Wells Fargo is kind of like the fork in the road for your career, and when you kind of went down this path.
That's it. That's absolutely true. And if it was not for that phone call, I mean, I'd be still trying cases, which, don't get me wrong, was a lot of fun. But the TCPA, I think, was definitely my true calling, helping protect people from cases that have tremendous liability, right? That can really put somebody out of business, just shut you down, no matter how rich you are, no matter how successful you've been. A TCPA class action can absolutely destroy your business, and it's just not fair. And I love the idea of being able to dedicate my career to keeping people safe from something that's very unfair and really can destroy a business and even drive people into bankruptcy, because you can be sued personally, even if you have an LLC set up. It's really pretty bad.
Yeah, that's one of the most mind-blowing parts about TCPA is how they can go after individuals for legally. So we'll get into that a little bit more later. But so back to your nomiker, the czar of TCPA world. How did that come about? I mean, it's amazing. I love the czar part. Like, that's amazing. But how did that come about? Did someone dub you that?
Yes, I was dubbed. So I started my career, as I mentioned, at kind of a smaller firm. I went to a regional firm, and then I developed a big national following, a big national practice. So I had to go to a big national firm, and the firm I went to at first was called Dorsey and Whitney, very nice firm. And they had an office here in Southern California. And very quickly, management of the firm kind of recognized me as a fairly capable fella. And so they made me the managing partner of the office, even though I'd only been there for maybe a year. And I was fairly young compared to, of course, some of the gray hairs that had been there for about 25 years. And one of the guys that was there, a former partner at a firm called Pillsbury, really nice guy, really, very established in the industry, would come by every day after I was made the managing partner and say, there he is, the czar. And it was kind of playful, but he did it every day. And when he first did it, I remember thinking, the hell, get that off of me, man. I'm gonna go take a shower. Don't call me the czar. It's a weird thing to be called, right?
Right.
But over time, it kind of started to sink in. And after I left Dorsey and went to a different firm, I decided like I really had to go back to good old fashioned guerrilla marketing. Having that as a brand, the czar, it turned out to be incredibly powerful. People really have a response to it. Now, unfortunately, most of the initial response is generally negative. Like, who the hell is this guy calling himself the czar, right? That's how most people initially respond. But it gives you that hook, right? It gives you that in. And I think as most salespeople would tell you, you'd rather have somebody have a reaction, even a negative reaction, but remember you than have no reaction and forget you. And so, people start to get multiple exposures to this person called the czar. And over time, they kind of get past the initial, like, what the hell's a czar, and get into, what, I like this guy. He knows what he's talking about. He's very capable. He's got some great clients. He takes care of people. He really cares. And all of a sudden, I'm a benevolent dictator and not some, gross guy from the 19th century.
Yeah, you're not Peter, or you're not Ivan the Terrible. You're Ivan the Great. Or
there you go. There you go.
So, all right, I know a lot of people on the call probably have some degree of understanding of like what the TCPA is, but for those on the call who are unfamiliar or just have a very, very minimal knowledge, can you kind of provide like a 10,000 foot view, like what is TCPA and what does it entail?
Yeah, so let's talk about it philosophically, okay? Because the TCPA is two things that you need to keep in mind. The first thing that it is the law that is supposed to stop your phone from ringing. All those robocalls that you get, the TCPA is the thing that is supposedly supposed to stop that from happening. Of course, it doesn't work. It's never worked. It's a bad idea. It's poorly executed. It's just bad. But it is the federal government's official response to the robocall epidemic in this country. And Congress has doubled down on it, tripled down on it. So it is something, if you're making outbound calls or if you're accepting leads from companies who are making outbound calls, you absolutely have to keep this statute in mind, because it is literally the statute that applies to that conduct. Okay, so we're going to talk about that. So that's philosophically one thing that it is. And we'll talk about what it says and what you can do and what you can't do. But also, and almost equally importantly, philosophically, it is something else. It is the biggest cash cow in American history for plaintiffs' lawyers. So yes, it's supposed to stop robocalls, but it doesn't. But what it also does is it enables people to sue you for $500 per call that you make or that you accept that's made essentially on your behalf. $500 per call that does not comply with the statute, and class actions are enabled. So if you make one illegal call that goes to the client of the plaintiff's firm, they can sue you for every other call that you've made if it violates the statute, all in one case. And you can go back 4 years. It's absolutely crazy. And so more millionaire, let me say this very clearly, more millionaire plaintiffs' lawyers have been made under the TCPA than under any other federal statute. It is the absolute biggest golden goose for the plaintiffs' bar in history. It is widely abused. There are litigator trolls out there that do nothing but file TCPA cases for a living. There are plaintiffs' lawyers who do nothing but bring these cases. And guys, these guys are rich, millions, tens of millions of dollars. These folks have houses and boats and planes and purchase buildings out, wherever. They are loaded. They are highly sophisticated. They're very intelligent. And when these guys come after you, right, you have to turn to a guy like me, because it's kind of like, they're the really bad guys. And I'd like to think of ourselves at least as like the really good guys that can do battle with these folks and keep people safe. The unfortunate part, though, of this whole thing, as you can imagine, is it's terribly expensive, right? Which is why compliance on the front end is so very, very, very important, because even if you are successful in defending one of these suits, they're not cheap. I mean, it's just the reality of the situation. They are not cheap. So you really want to focus on compliance, because the TCPA is not just, right, this robocall preventing statute, allegedly, even though it doesn't work. It is also the biggest cash cow in history and drives a ton of litigation, and people are looking to sue anybody, even small people. I'm not saying that you folks are small, your businesses are very important, and I'm sure that many of you have tremendous revenue, but whether you're small, medium sized, or big, the plaintiff's bar is going to come after you. And it's pretty brutal. So that's at a high level, that's philosophically what to think about when you think about the TCPA, robocall response, but also cash cow. And then as we dive down now in terms of what does the TCPA actually say, right? Like what does it say? What are the requirements? Two big requirements to keep in mind. Okay, one is the use of regulated technology. And we're going to spend a little time talking about what regulated technology is, but generally speaking, it's pre-recorded calls, artificial voice calls, such as ringless voicemails, and the good old-fashioned like, hello, this is Bob from George's insurance shop. Would you like some insurance, right? All of that is going to be regulated technology along with auto dialers. Now, there's a very specific definition of auto dialer under the TCPA. We'll touch on it a little tiny bit, but suffices for you to understand that if you are buying a list and making outbound pre-recorded calls or auto-dialed calls, or if you are buying leads from somebody that is doing that, the TCPA says you cannot use that technology to contact a cell phone without express written consent. And express written consent in this context is very specific. There's a code of federal regulations, which is called the CFR. There's a CFR provision that has 9 different things. They're called the Troutman 9 that these disclosures have to have in order to be enforceable. So pretty high standard here. We'll talk a little bit about what you can do to make sure you've got the right consent. Okay, so that's one requirement, right? Thou shalt not use regulated technology to contact a cell phone for marketing purposes without express written consent. Boom, that's one. 2, numbers on the DNC list. You folks probably know there's something called the DNC registry out there. This is a separate provision. Either one of these can be independently enforced. If you are calling phone numbers that are on the DNC, even if you are calling manually, not using regulated technology, you're picking up the phone, you're making outbound calls. Again, if that number is on the national DNC list, you cannot call it without express written consent. So if the number is not on the DNC and you are not using regulated technology, you're just picking up your phone and calling somebody, you can still legally do cold call marketing in this country, believe it or not. That is still legal in most states. Got to pause. We're talking about federal rules. There are state rules, which are different. But at the federal level, you can still pick up a phone, make a manual outbound cold call solicitation to somebody you've never met before if they are not on the DNC. If they are on the DNC, you cannot make that call. That is a violation of the TCPA, separate and apart from the regulated technology provisions. So those are the 2 big things that you need to understand about the TCPA. You can't use regulated technology for marketing purposes to a cell phone without express written consent. And you can't call a number that's on the DNC for marketing purposes, even manually, without express written consent. If you do either of those 2 things, which I know a lot of you want to do, if you do either of those 2 things, it is $500 per call. And again, these class actions are enabled. And as we hinted at earlier, unfortunately, personal liability is an issue here. That means that you personally can be sued for your personal fortune, your car, your house, your bank account, not just your business. And that's what makes this statute horribly, horribly dangerous.
So can even like team members, so say you have an employee who's making calls, can they be liable personally as well?
Yeah, it's craziness. There's cases that have essentially said, you can imagine a call center with like 300 people in it, right? Yeah. The poor schmo, sitting there at the 59 dialer, he's got absolutely no power in terms of who's calling next. He's just sitting there getting a call connected to his headset, right? He can be personally sued. It's craziness. So can the campaign manager, so can anybody involved in compliance. There's cases that suggest the CEO, if they're involved in crafting a business plan that violates the TCPA, the CEO can be personally sued. I mean, 99% of laws, if Chevron goes and dumps, 100 billion gallons of gasoline into the ocean, no one's going to get personally sued. Chevron's going to owe a bunch of money, but it's not like the CEO or any board member is going to get sued personally. But under the TCPA, it's totally different, man. Everybody on the chain, from the CEO all the way down to the guy that's dumping the gasoline into the oil, or in this case, just the guy that's making the outbound call, that's picking up the outbound call, that's sending the text message. Everyone can be held personally liable. It's pretty messed up.
So I want to get more into some of the specifics of the TCPA in a second, but before we do that, I had a question about, so you've been involved in over 500 class action litigation, right? With TCPA litigation. So in your experience, like what are some of the worst penalties you've seen assessed from people losing this type of litigation?
Well, I never lose, buddy. That's what I'm here for.
Good point. But
I'm kind of kidding.
Yeah.
I can't guarantee anyone's success in any litigation, but we have been very successful. But part of success in this game is knowing when to get out of the case, right? And so a strategic settlement can actually be a victory, tragically, in these cases. And so, we picked on Wells Fargo earlier, so I'll just use them as an example, right? You go back to 2008, and really nobody knew about the TCPA. Nobody understood it. 2009, 2010, people thought it was like a marketing statute. They didn't realize that if you were using an auto dialer or predictive dialer to contact a cell phone, even for a servicing informational purpose, like that triggers the TCPA. And so, there are some massive settlements, and it's public record that Capital One settled a case for $75 million. Wells Fargo has settled several cases. We engineered it so it was never such a big number, but they've settled several cases for over $1 million. Just last year, Keller Williams settled a case for over $40 million. And of course, when you look at verdicts, Visalis was hit. That's a multi-level marketing company. They were hit for over $900 million in a jury verdict. A company called Golan Entertainment was hit for $2.1 billion. Dish Network was hit for $156 million. And then, near and dear to the hearts of folks here, Allstate has had to settle a couple of these cases recently. Just last year for a couple $1 million. So it's a persistent threat. It is something that can. There's stories of a guy that lost his house because of a TCPA judgment. In fact, Regal Entertainment, I believe, was the name of the very old movie theater company that went out of business, and they went bankrupt many years ago. Was actually bankrupted by a $50 million TCPA judgment.
Oh man!
So this stuff, it's out there, it's real, and it continues to live on and haunt people to this day.
Yeah. And in your experience, have you seen many like small business owners, or even like just independent business owners who've been subjected to massive penalties like this, like say like an insurance agency owner? Is that common in your experience?
Yeah, so let's take the Gebka case as an example. That was a case against Allstate, and so there was just an independent Allstate guy, out there selling Allstate, and he bought some leads, from a company that had bought other leads, and the company all the way downstream was using like a call center in Pakistan or something, right? And the allegations are at least that they broke the law, and so the company that was in between, the lead generator, essentially got put out of business. The independent guy that was selling the Allstate, right, he's facing millions of dollars in indemnity demands. I think Allstate actually ended up taking care of the guy. I don't know how that one turned out. Yeah. But I know the lead supplier just got destroyed, right? Lost half his revenue, almost went out of business, had to lay off 12 people. So people in the chain of these things, they really do get hurt pretty bad. Now, whether or not the independents, or I don't know if the folks I'm talking to are largely independents, if you guys are captives, how your relationships work, you're going to know your relationship with your company better than I do. And so if it's the kind of relationship where you think, hey, look, they're going to protect me, they'll indemnify me, it's okay, good for you. But if you're out there, Bob's insurance shop, and you're selling, 4 different kinds of insurance, and because of your activity, not just you, but State Farm or Allstate, one of these big boys, gets hit in a TCPA suit, I would not assume that they're going to let you walk away from that, scot-free. So it's another level of risk. I guess that's something, for insurance agents to keep in mind. it's kind of, you get pinched both ways, right? The plaintiffs are going to come after you individually. They're going to try to sue you directly, but they're going to try to pierce even past you and get to the insurance provider, because that's the big name, right? That's the deep pocket. That's what they really want.
Yeah.
And so if they're successful, now Allstate or whoever is going to owe millions of dollars to this guy, and you're sitting there in the middle. So that's not really you want to be. So again, compliance is really very important here.
So I want to take a step back because, all right, so it's clear like this is, the stakes are high. Like this is something that, you know, everyone who's making outbound marketing calls needs to take seriously, right? Obviously, like there's a lot at stake. So the specifics of the TCPA, you mentioned like the auto dialers and certain technology that falls under it. What else falls under TCPA guidelines? So you can make like direct calls, you said, but not using an auto dialer, that would fall under it. What else besides auto dialers are regulated under that auspices?
Yeah, so again, there's two big provisions, and technically there's like 10, okay? But these are the two big ones that drive all the litigation. There's some other requirements that, you know, if you attend some of my webinars or you go to my conference or you check out TCPA World, you can learn all the nuance of the other 8. But the two big ones you just have to keep in mind are, again, that regulated technology provision and the DNC provision. So if we want to break down the regulated technology provision a little bit more, so we start at the top with auto dialers, right? What is an auto dialer? You know, there's a lot of talk out there following a case called Facebook, which is a US Supreme Court decision, that you have to randomly generate telephone numbers in order to be using an auto dialer. And I'm here to tell you that's not true. It is true that the definition of auto dialer now is pretty narrow at the federal level. Different courts, though, in different parts of the country, take a different position in terms of what an auto dialer is. For instance, here in California, I know some of you are in California, the Ninth Circuit Court of Appeals has said, in fact, that if you're using a dialer that creates random telephone numbers, then you're using an auto dialer. Otherwise, you're not. Okay, but that's just in the Ninth Circuit. Right. In a lot of other states, right? And remember, people are protected based upon the law in their state, even if you are in California. You're in California, but you're calling somebody in Pennsylvania. I'm not saying that you would do that. I don't know, you know, if you guys have geographic limitations with kind of the products that you're selling. But let's just assume you're calling out of state. The law in the state of the consumer where you're living is the law that's going to matter. So for instance, Florida has a specific state law currently, although it might be amended soon, got to keep up, that is extremely broad. And if you're using any form of technology that can automatically select a phone number to be called or automatically dial a phone number, that is going to constitute an auto dialer in Florida, even if it doesn't constitute an auto dialer in California. So you have to keep all of these kinds of geographic mappings in mind when you're asking yourself, am I using an auto dialer? But just kind of stepping back, you know, just from a logical perspective, you know, with the TCPA rules that we've already started talking about, you have to keep in mind, if you're using any form of automation, anything that's going to help you leverage a quicker, you know, attempt, you know, you're calling 3 people at once instead of 1 people at once, you're doing something with the systems dialing the number for you, you're just sitting there waiting to get connected. You have to assume that somewhere that's going to be an auto dialer, okay, somewhere. So you have to think to yourself, do I have the right level of express written consent in order to make this outbound call? If you don't, I say don't risk it. Even if you might pull it off, because in California or Nevada, you know, the laws can be tighter versus other states, you really got to be asking yourself, is that a risk that you want to take? And obviously, if you want compliance advice, right, give us a call. We're happy to help you, right? This is what we do for a living, is we help people to have their kind of strategic business operations aligned with the law, including at a state level, so that you know exactly what you're allowed to do and exactly what you're not allowed to do. But at a high level, right, just kind of think to yourself, this could be a trigger, this could be an issue. Maybe I'll just pick up my phone and call instead of using this technology. So that's one piece of regulated technology, the auto dialer. But the second piece is really kind of the most important, right? Because I say right now, 90% of cases that are being brought on regulated technology are being brought on pre-recorded or artificial voice calls. And these are calls like your slide broadcast or your ringless voicemail. Maybe perhaps phone burner will enable, you know, these pre-recorded calls. I'm not sure what platforms people are using here, but these pre-recorded calls, you know, they obviously they allow you to scale. It's very efficient. You feel good. And you can send out 100 pre-recorded calls in 1 minute. And you don't even have to lift a finger, right? So that feels like an attractive value prop. Problem is that these things automatically trigger the TCPA. So you absolutely have to make sure you have express written consent that is valid. And one of the things that we can also talk about is where this express written consent is coming from. A good source like Everquote, maybe you've got one level of risk, which is lower. Other sources that are providing leads. Remember, you're pregnant, right? If they screw something up downstream and you're using a pre-recorded call, well, that's your baby. You're stuck, right? You're not going anywhere. You are going to be liable for conduct that somebody else engaged in because you made the outbound call, even though, let's say, your contract says that they have to give you express written consent, they have to give you valid consent. If they screw that up, right? If you're not auditing that, if you're not validating that, then when you send that pre-recorded message out, you're the one that gets sued. They don't get sued, you get sued. So you got to be really, really, really cautious who you're doing business with in the lead gen ecosystem. And that's why I tell clients, basically, if you're buying leads, you should not be using pre-recorded calls. I don't care what they tell you. It's just too risky, and it's your risk, not their risk. And again, pre-recorded calls include pre-recorded voicemails and ringless voicemails, which I know people really find attractive. On the SMS level, good news, bad news. If you're sending out a text message is not a pre-recorded call, which is good news, right? That means that the TCPA does not automatically apply to text messages. But if you are using an automated system to send text messages, then you might be back up to the same rules, right, as automated phone calls that we talked about before. A lot of nuance here. So, I'm trying to keep this at a high level. I can't give you legal advice because this is just a webinar.
Yeah.
But as you can see, there's a lot of nuance. There's a lot of kind of striation in terms of what the rules are. But again, that's regulated technology. Never forget, you've got the entire second area of law, right, which is the DNC provisions. And even if you're calling perfectly manually, even if you pick up your phone and just type in a number, if that number is on the DNC list, you cannot make that call unless you have express written consent, an established business relationship, or an inquiry, which is somebody specifically reached out to you, not to insurance carrier, to you, and asked you a question about the products that you have. That's an inquiry. Or an established business relationship, which means it's your existing customer, right? They've signed something with you in the last 18 months. You can pick up the phone, you can call them, you can say, hey, your policy is due to renew, auto renew, or we have a new policy, or if you considered X and you considered Y, that's all fine. But when you think about like a win back, right? So-and-so went with a different agent, went with a different broker, a different product, and now you haven't talked to that person in 2 years. Hey, I want to get this person back onto my sheet. You're not allowed to make that phone call if they're on the DNC list.
So you've mentioned like the express written permission. I think you alluded to like there are certain requirements for that. Can you break that down? And is it different for like DNC express written permission versus calling someone with like an auto dialer or a pre-recorded message? I think you mentioned you need express written permission for that too, right?
That is correct. So 47 CFR 1264 or 64 1200 F9. Just go read it. No, I'm kidding. So there's a bunch of provisions that are required. The disclosure has to specifically say that the consumer is going to be accepting marketing. This has to be a conspicuous disclosure. It can't just be like part of some terms and conditions somewhere. It has to be right there in front of the consumer, right where they click the button. Hey, if you click this button, you're going to get marketing calls. It has to say who is going to make the calls. It has to say who is going to provide the service that's being consented to. It has to specify, right, the reason that they're going to receive calls. It can't just be like, you're going to get marketing calls forever. No, you're going to get marketing calls because you want information about an insurance offer or an insurance quote. And it has to have some very specific language that consent is not a requirement of obtaining any good or service. So you have to have a flow set up that, even if they don't click that button, even if they don't give you consent, that you can still, they can call you on a 1-800 number, they can visit a website and fill out, send you an email. It has to be a different flow that they can still get a quote from you. They can still get, whatever product or service or insurance bundle you want to offer them without giving you that consent. So it can be an operational hurdle for some folks as well.
So I hate to, I don't want to get sidetracked. We got a bunch of questions popping up from the audience.
Yeah, let's go.
So James asks, if you're using an auto dialer software where you will answer or leave a voicemail personally, all calls that are connected to a person who answers, where is the liability? Buying the lead list from the lead company, whether hot or aged. So Does that clear?
Also, because you're using an auto dialer in that hypothetical,
Right.
even if you're leaving a live voicemail, you're already triggering the statute. So in that hypothetical, because you're using an auto dialer, you have to have express written consent. The liability would attach if the lead that you're obtaining is not valid. Now, in the context of a live lead, there's always risk because, I mean, at least according to some people, 30% of online leads are fraudulent, i.e. just, a bot did it or somebody purchased a list of non-consented data and then paid somebody to fill out forms and submit it. So you always have that risk right out of the gate. Aged leads, though, raise a huge additional issue, really two additional issues. One is that phone number could have changed hands, right? If you're buying a lead from somebody that's 6 months old, a year old, the odds of that lead still being connected to the phone number that was provided at that time, I don't know, maybe it's 50-50, maybe it's not that bad, but the bottom line is if you buy 1,000 leads that are 6 months or a year old, a significant percentage of those, 100, 200, are going to have changed hands. And that being the case, you no longer have consent. So when you call that number, you just violated the TCPA 100 times. And that's 100 times 500, right, is your liability for that. Now, there is something called the reassigned number database. And all of you that are doing outbound calls at scale, all of you that are making outbound calls to phone numbers where the lead is 60 to 90 days old or older, you really need to be using the reassigned number database. Let me tell you, it's an absolutely critical tool. It's put forth by the FCC. It is the official database of the US government, essentially, when it comes to reassignments. And that's the only way that you can successfully protect yourself from a wrong number call in the age lead context. But the other risk of age leads, of course, is that somebody could have said, I don't want these calls anymore. The lead sellers, the aggregators, don't really do the best job of flagging which ones of these leads the consumer said don't call. And so again, you might get a lead where the consumer's already been like, I don't want to call on this insurance. Stop calling me, leave me alone. And now you're making a call to somebody who's going to then sue you and say, falsely or otherwise, if I told them to stop calling and here they are calling me, and you're like, well, that was somebody else, it wasn't me. Well, good luck proving that in court, right? So those are the big issues with age leads. I do not like age leads. I get it, they're cheaper, sometimes, just from an economics perspective, that's what you have to go with. But just understand it's a lot of risk.
Yeah, and that's one thing. Everquote doesn't sell any age leads, and that's a part of it. So this is actually an interesting question here. Someone's asking, are businesses viewed under the TCPA the same as consumers? So meaning,
yes,
if you're calling businesses, they protect it. Is it the same deal as if you're calling consumers?
Yeah, the short answer is yes, with an asterisk. So again, regulated technology, if you are calling a cell phone, doesn't matter if it's a business cell phone or not, it still triggers the TCPA. The idea under the TCPA is that businesses are also consumers of telephone services. So it's not consumer in the traditional sense of the word when you think of consumer, it's consumer of telephone services. And the business cell phone is a consumer of telephone services. So if you are calling a business cell phone using regulated technology, you are absolutely going to trigger the statute. Now, the asterisk comes in on the DNC side. And it's really interesting the way the law is set up. The law says if you are calling a residential line, then you are not going to trigger the DNC. But there's a problem. And the problem is COVID. Because all of us now, including me, are using cell phones, both as a business phone and as your personal phone, right? And so even though a phone might be used by a business, it might even be on a website somewhere, right, as a business number, that same person could still be using that as their residential phone. That is their phone number, right? No one has a landline anymore. And so the case law is very clear that if the plaintiff says, hey, look, I use this every day. I talk to my mom on this phone. I talk to my friends on this phone. This is my phone. The mere fact that it's also used as a business phone will not protect somebody from a DNC claim. So it does not matter that you are intending to call a business or that you are calling for a business purpose. What matters is how the phone is actually being used factually, which of course you can't know. And so it's a real trap for people who want to do things the right way. They're doing B2B calls. there was a case called Chenette versus Porch out of the Ninth Circuit Court of Appeals that's here in California, that just obliterated businesses, because it essentially said, if you are calling for a business purpose, you, the caller, have to prove somehow that the phone number you have called is in fact a business line and used essentially only for business purposes. And how are you going to prove that, right? So it's a real trap. It's a real problem in my view. It's really bad case law. There's a big story behind how it happened, and it's just, to me, it's borderline tragic, if I can use that word. But it's just bad. It's all bad.
Are there any cases pending that might correct that?
No, although, well, there was an attempt to have the Ninth Circuit reconsider the issue, what's called en banc, which is where all the judges in the Circuit Court of Appeal get together and reconsider something, but that was denied. It could go up to the Supreme Court, but it's not going to happen. Other courts, around the country, we talked about this earlier, different courts do different things.
Yeah.
Other courts have looked at this and said, no. I mean, there are some district courts that have thrown out these cases and said, hey, look, this guy had on a website, that, it was his business line, so I'm going to throw out this lawsuit. But those are pretty rare, and they generally only happen with a guy like, for instance, like Shelton, right? A guy who's filed a lot of TCPA suits, and there's a lot of smoke, maybe, that he might be setting up lawsuits. Not saying he is, but there's suggestions that that's happening. And so a court will say, well, wait a second, this guy's filed 150 TCPA lawsuits, or 10 lawsuits regarding calls to a business line, yet he keeps his cell phone up, as his business line, on all these websites. Why is he doing that? Why doesn't he change it? Why doesn't he put stop when someone sends him a text or something? So there is some line of cases that basically tries to cut down on the trap element, but you should still be careful, because I'd say right now the majority rule is, hey, look, you've got to prove that this was not a residential cell phone, and
Right.
I mean, good luck with that.
So yeah, you touched on this before, but we have a question about, is there any like case law as defining what an auto dialer is? And they say that they've heard that even if you manually dial using a system that could be considered an auto dialer, you are in violation. I'm not familiar with that particular product.
You are correct. That's the old capacity argument. So the case law on ATDS remains a bit of a mess. As I told you earlier, it is better after the U.S. Supreme Court case of Facebook. I would say directionally, from 3 years ago, 4 years ago, everybody is safer, and that text messages are the safest channel right now of communication at the federal level. But that does not mean that there's no risk. And whoever just made that comment has a tremendously important point, which is the way that the statute is written. It's not the use, well, outside of the Third Circuit, we'll get to that. It's not the use of a random or sequential number generator. It's not the use of the automated features that matters. It is the capacity of the system to operate in that manner. The old analogy that you look at is, you're driving down the road, speed limit's 55, you're going 50, you get pulled over and you say, I wasn't speeding. And the cop says, yeah, but your car has the capacity to speed. And even though you weren't using that capacity, the mere fact that you have the capacity to speed is enough to trigger the rule. And that's how it is under the TCPA. If you are using a system that has the capacity to be an ATDS, it doesn't matter if you're driving in a slow lane. It doesn't matter if you're using that system in a manual fashion. The mere fact that that system has the capacity to be an auto dialer is sufficient to trigger the statute and cause all these fines in most courts. Now, the Third Circuit Court of Appeals, and that's Pennsylvania, Delaware, and one other state, I should know this, I think New Jersey. In the Third Circuit footprint, the courts have said, no, that's crazy. Only if you're using the automated functionalities are we going to say that you're using an auto dialer, which truthfully makes sense. Logically, that makes sense. But on the other hand, that's not what the statute says. The statute does look at whether or not the capacity of the system is present, not how the system is being used. And really, Congress should fix that, but they haven't. So
does kind of like a product of it being written in the early 90s when like those type of auto dialers were like the standard for like those spam calls that they were trying to combat.
Yeah, that's right. I mean, look, this is where I get on my soapbox and I say, never, ever, ever elect anyone to Congress who's not a lawyer. This is why we have so many bad laws, People pass laws, they're not lawyers, they don't understand the impact, and they write really bad, vague laws. And that was the fact with the TCPA. It was trying to do one thing, but my goodness, these schmoes over there in Congress, they just did not write it properly. And so as a result, we've got 30 years of litigation ongoing. So vote only for attorneys. That's my 2 cents of unsolicited political advice.
Good advice. All right, so a good question here from James. He says that, so I think you touched on this earlier too. So if you're a producer working for an insurance agency, buying your own leads, using an auto dialer that automatically calls the leads, using one phone number outbound, should you form an LLC to protect yourself personally, or is that not effective? I think you mentioned this earlier, that LLC won't protect you individually from liability, correct?
Yeah, so I look, I can't give you legal advice. Okay, let me just start with that. And there might be a lot of other really good reasons to form an LLC. So I'm not telling you not to form an LLC. Please hear this. But the point from a TCPA perspective is that you can't protect yourself with corporate form from individual liability. So if you buy a list, you decide you're going to hit it with an auto dialer, you're the one sitting there fielding the phone calls, you're going to be personally liable no matter what, potentially, right? No matter what. Now, do you want to throw a roadblock and get an LLC and protect yourself from other potential exposure? You should talk to a lawyer about that. I'm not a lawyer for this purpose. I'm just a webinar guy. But in seriousness, I'm always happy to help you if you've got some questions along this line, but we can't do that. I can't give you specific legal advice in a webinar.
And just as long as it's okay with you, Eric, like we can put your contact information on the email we send out to all the registrants if anyone.
Yeah, please do. And you can visit troutmanamin.com, TROUTMAN, AMIN.com, and TCPAworld.com, which is totally free. And we break down every case, every day, every development around the TCPA. You don't have to sign up. There's no barriers to entry. You don't have to give us your personal contact information. You just come and get free content. Cannot emphasize enough how powerful and important that platform is to help educate you, TCPAworld.com. But keep going, sorry.
And we'll include those links in the email that goes out for everyone too. So just keep an eye out for that. So another question from an audience member. So they're using an auto dialer where the lead answers. So they're asking if they don't answer and you have a pre-recorded voicemail and email, is there liability if you're using an auto dialer in that context?
Yeah, and so I want to reemphasize that either using an auto dialer or using a pre-recorded call is going to trigger the statute, right? Mm-hmm. So here you're telling me you're using an auto dialer and a pre-recorded call. So yeah, you're double triggering the statute. If you're using an auto dialer, automatically you trigger the statute. If you're using a pre-recorded call, again, separately, you're automatically triggering the statute. Now, again, you are allowed to do that if you have valid express written consent, right? So if you've got that valid consent, you are allowed to use this technology. If you're buying leads, however, just remember, you are now stuck with whatever that lead provider has done. If it's a valid lead, a real person went onto a real website, filled out the correct form, hit the button, you are fine. You can absolutely use that technology. But if that lead supplier is lying to you, if their form is bad, if the wrong person was there, if it's an aged lead and this phone number changed hands, right? All of a sudden now that you have that risk on your shoulders, you can be sued, even if you did nothing morally wrong, right? Your contract says, I only want consented real leads, and they give you a fake, bad, non-consented real lead. You have done nothing morally wrong, but yet you can still be held liable. It's a rough, tough world out here.
And this isn't just like hypothetical. There's been plenty of people who face litigation
all the time.
With vendors.
All the time. In fact, I say right now, at least half of my portfolio of class litigation that we're handling here at the powerful Troutman Amin law firm, half of that is probably from alleged fake or inaccurate leads. Now, I'm not saying that they were really fake or inaccurate. Of course, I'm going to argue that they're all valid, but that is the allegation.
So got a question from the audience. Are there state DNC, they're asking state DNC lists versus federal DNC lists? Is that like a thing?
There are state lists. We put those up on TCPA World a while back. You go to TCPAworld.com and just Google, or not Google, ssearch state DNC list. You can see the list. I believe there are, and Angelica, my paralegal, is going to kill me for not knowing this off the top of my head. I want to say there's 8 states that have their own specific DNC list. that does need to be separately scrubbed.
So do you know, this is another question from the audience. Are you aware if there's like any software that like an independent agent can use to scrub their lists against state or federal and or state lists, DNC lists?
Oh, sure. So there's a lot of that. I mean, that is the good news, right? Like you're not out there alone. Yes, there's fancy, expensive lawyers like me that no one wants to pay for, and that's fine. But there's good vendors out there that are far less expensive than we are. I mean, I would start with like DNC.com, Contact Center Compliance. They're an absolutely wonderful vendor. I love them. Now, look, I should say I never endorse anybody, although it sounds like I'm endorsing them. I just really like them. They're buddies of mine, and they take compliance very seriously, and they help smaller call centers. You also want to be thinking about, what kinds of dialers you're using, right? I don't know what you folks are using. If you're using something like a Phone Burner or a Vulcan 7 or a Mojo, I don't want to say anything bad about any company. I don't want anybody to, come down and say, oh, Eric, you defamed me. But if you look at the case law, I'm not sure that those companies are really, have the best luck so far. But there's other companies, I think, that have really kind of proven themselves or really tried to take compliance or put compliance kind of at the front end. You think of a company like Convoso or Consumer Dynamics, the makers of Safe Select, for instance. And then those of you that are interested in conversational AI, one of my big clients is Drips. They're a nationwide platform that focus on conversational SMS messaging. They're really big into compliance, and so they build in all the business rules around date and time zone restrictions and state by state rules. And Safe Select does that as well. So it's, I believe, Convoso. So there are definitely tools out there. That's the good news, right? The good news is that there's a whole, as much as there's a bad ecosystem of bad lead generators, there's also a good ecosystem of good lead generators. There's an organization called REACH, Responsible Enterprises Against Consumer Harassment. I'm the president of the dang organization that has a bunch of good lead suppliers that are members, and they've pledged the highest standards of leads. Again, CCC, the DNC.com folks, great resource, great help. And then these platforms I was mentioning, right? All these companies are there to help you. There's a cost component, obviously, but to me, that's the penny of prevention, pound of cure, whatever the heck that old analogy is. I'm not great with my old maxims.
Yeah, the old the idioms. Yeah, I don't remember that one. It's a penny of prevention, a pound.
Penny, it's something like a penny earned. No, it's pound of prevention, pound of cure. Ounce of prevention, pound of cure. I think that's what
I think that's
there it is. I put the penny in there. The penny got mixed up.
Yeah, they're juxtaposing the jump over a penny or jump over $1 to get a penny or something. I don't know. There's a million of them. Anyway, I just want to say thank you to John for he posted a link to TCPA World article on state specific lists. And
thank you.
Pooja followed up.
And Kathy got the penny wise, pound foolish. That's what I was going for.
Yeah,
that was the one. That was the one. Thank you.
Yeah. And Pooja followed up just to say there's 12 states currently with their own DNC lists now.
Pooja Amin, my esteemed partner, absolutely fantastic attorney. She was formerly with Loan Depot in-house. And I stole her. No, it's not true. That's not what happened. But yeah, so she's the Amin of Troutman Amin.
All right, this is a great question. It's actually a question I had. Esther asks, will E&O insurance cover TCP related suits, or do you know if there's any other insurance products that can help protect an agent from TCPA liability?
Yeah, these insurance companies are way ahead of us on TCPA these days. Every general policy, every one of these policies has a specific TCPA rider that says we will not cover you for TCPA because TCPA is way too risky, way too dangerous. The stakes are way too high. There's way too much litigation around it. 99% of insurance companies will not touch it with a 10-foot pole. However, there is one guy I know who specializes in brokering TCPA insurance for people. It is terribly expensive relative to the coverage. But the nice thing about it is they do provide defense, right? So even though you don't get much indemnity coverage, you do get a defense so that your lawyer costs at least are going to be free or very low if you get sued. Now the downside is that these insurance companies don't hire me, right? They hire people that charge about 1/6 what I charge, and you generally don't get the best defense as a result. Again, I'm not trying to defame anybody, just in my opinion, some of us are a little bit better specialized perhaps. But that is an option. And so if anyone wants that information, you can reach out to me. I'll connect you with my buddy Otto, who does that insurance.
So I know we only have a few minutes left. I just want to go over, like, what are some practical steps that you would suggest, like, an agent should be taking just to cover their bases? Like, I know there's a lot of specific things they can be doing, but what would be like your top 3 suggestions for agents to start protecting themselves?
Yeah, that's great. So first thing you should be doing is understanding that you are at risk if you're making outbound calls, right? So take stock of what kind of outreach you're engaging in. For small companies, right? One-man shops or one-lady shops, this should be pretty easy, right? Am I making outbound calls? Am I leaving ringless voicemail? Am I sending text messages? What platforms am I using? If you're at a bigger shop, or maybe you're a broker, you've got a bunch of agents that are acting kind of independently, you got to figure out what these people are doing, right? You cannot just let folks that are out there using your name or potentially your license to engage in conduct that you're not aware of. Okay, so step 1 is you have to understand what the universe of outreach is that you're responsible for. Okay, step 2 is you should probably consult with a lawyer. But if you're not going to consult with a lawyer, you need to at least ask yourself, are any of these outreaches that I'm doing, are these going to trigger the TCPA, right? And if you're doing a marketing outreach, you got to at least be thinking about the DNC. Am I scrubbing off the DNC? Am I only calling people that have a relationship with? Am I only calling people with an inquiry, right? If the answer to all those questions is some form of no, then you're in harm's way, right? You've got to be thinking to myself, I've got to make some changes here. And simultaneously, if you're using regulated technology to contact anybody, right, again, on a cell phone, you've got to be asking yourself, do you have the right level of consent? And I encourage you, educate yourself. Again, TCPAWorld.com is there. Again, we don't track anything. There's no ads. It is like free. Just go and read up until your eyes fall out. There are thousands, literally thousands of free articles on there. So you can educate yourself. That's why we have that resource, so that people can kind of better understand the law. But you should definitely consult with a lawyer. Really think about, do I need to spend a little bit of money on the front end to make sure that I'm safe as I'm engaging in this outreach? And then 3, you've got to keep control moving forward, right? Let's say that you understand your risk, you've made your assessment, you've decided what you want to do. There's always salespeople out there. They're going to try to get you to do something new, right? Or you're going to see so-and-so doing X, and you're going to think, oh man, that looks good. And, or so-and-so doing Y, and they're getting away with it. So why can't I? You got to resist temptation, man. The 10th commandment, it exists for a reason. Thou shalt not look at what your neighbors are doing and think, oh, that's a good idea, I'm going to do it too. You have to be smart, right? And make the right decisions for yourself, because I guarantee you, so-and-so and so-and-so might be getting away with it for now, but the TCPA never rests, man. It is a matter of time. Everybody eventually gets crushed by the statute if you're not doing things the right way. You have to take compliance seriously.
So I got someone asked if you would mind if we could post your contact info in the chat.
Yeah.
So I can go do that here. You mind if I post your email, or what's best for you?
Yeah, so you can always check out TCPAWorld.com. Someone put Eric at TroutmanAmin.com, which is not even correct. But I think that's my shadow account, but it's Troutman at TroutmanAmin.com. You can visit TroutmanAmin.com. You can visit TCPAWorld.com. You can Google Eric Troutman. You can Google Czar TCPA. I am the easiest man in America to find, for better or for worse.
All right. And then, this is an interesting question. Does TCPA apply at all to service calls? I wouldn't imagine so, because they're people you're doing business with, right? So
yes, so it will apply. So we've been talking about the 2 big restrictions, right? On a service call, guess what? The DNC is dead. DNC only applies to marketing calls. So the DNC component has gone away completely. The regulated technology provision is still there. Remember, I told you Wells Fargo got in a bunch of trouble way back when because they were doing servicing calls using automated technology. So you still have to have express consent. But here's the good news. For servicing calls, you do not have to have express written consent. You just have to have regular express consent, which, really good news, is presumed anytime you are sending a servicing non-marketing call to a cell phone number that the consumer gave you in connection with that policy. Okay. So if you're just reaching out to the number that they gave you to say, something that's informational, then you are fine. Now, let me caution you. The line between informational and marketing is very unclear. And if it is marketing at all, it is a marketing call. and something like, hey, your policy is about to expire, get a new one. Trust me, that's going to be marketing. All right. So if anybody thinks, I'm gonna do a reach out and encourage people to get some new product with me or renew their product, and it's going to be servicing, that is going to be marketing. And you're going to have express written consent to do that. A true servicing call is something like, hey, you didn't pay your binder, you didn't pay, last month's, $50. If you don't, your policy is going to expire. That is servicing. You can do that with regular express consent, even using an auto dialer. Of course, you can reach out for marketing purposes again to your existing customers, but you have to do it manually. Okay. The end.
So I think we're over time here. So we're gonna have to cut it short. We did have, I think, one more question.
Shoot me your questions, guys. Email them to me. If there's something I can answer at a high level. Again, I can't give you legal advice until you are a client of the firm. But at high level discussions, look, I'm the czar. I take care of my people. I'm happy to share information. Check out TCPA World, and I promise you, there's a lot of answers there too.
Yeah, and we'll send that link out to everyone with the recording of today's session within 24 hours. So you should get it by this evening, tomorrow morning at the latest, everyone who registered. So this was a great session. I'm really, really thankful for you to come, that you were able to come on with us and really break down some of this basics, something that's very opaque for a lot of people. So I really appreciate it, Eric, and appreciate everyone's time joining us here for this excellent session. Again, we'll be sending out the recording within 24 hours, and we'll have Eric's contact info into the TCPA World website, which I'd recommend everyone to check out when you have some time. But just want to thank everyone, and we'll see. Thank you, Eric, and we'll see everyone on our next webinar.
Thanks, everyone. Bye-bye.
Bye, guys.